Mr. Shaw has been turned loose from the freeway, and let me introduce him to you. Ted Shaw graduated with honors from Wesleyan University and took his law degree at Columbia, where he was a Hughes Scholar. He then joined the Civil Rights Division of the Department of Justice as a trial and appellate attorney until 1982, when he resigned in protest of the Reagan administration's civil rights policies. He then joined the NAACP Legal Defense and Educational Fund, which some describe as the nation's premier civil rights law firm, until 1990, when he went to Michigan Law School to teach constitutional law, civil procedure, and civil rights. He rejoined the LDF in 1993 and is now the top executive of the LDF. Until 2008, Mr. Shaw also taught at the Columbia Law School, Temple Law School, and City University of New York Law School. Mr. Shaw has a distinguished career in civil rights cases, including as counsel in the 2003 Michigan undergraduate affirmative action case, Gratz versus Bollinger. Mr. Shaw has testified often before Congress and state legislatures and has traveled and lectured on human rights throughout Europe, South America, South Africa, and Japan. He has received awards reflecting his dedication to social justice from Columbia University and also from his alma mater, Wesleyan University. Mr. Shaw.
Thank you and good afternoon. First, let me apologize. I teach civil procedure 4 days a week, and Thursday is the last day of the week that I have to teach, and I was driving down with my wife and daughter, and so we ran into some weather-related delays, and so my apologies, and I particularly apologize to my fellow panel members because I do not get the benefit of what they had to say, which of course would help to wind me up and get me going. But I'm really happy to be here at the Federalist Society convention. I used to, when I made a couple of these appearances, say that it's kind of like for me going into the lion's den, but I have actually come to really appreciate these opportunities. There's a whole lot we don't agree on, but it's always, for me, stimulating, and you know, there are many members of the Federalist Society whom I have interacted with and whom I've come to know, and so it's always good to be here. Now, in my introduction, I need to just clarify a couple of things. I actually am not the Director Counsel of the Legal Defense Fund any longer. I was, and I spent 26 years at the Legal Defense Fund, but I now teach full-time at Columbia Law School, and so I just wanted to clarify that because I don't want to hold myself out as something that I'm not, at least anymore. Let me also suggest a couple of things about the comments that I did hear, the little pieces of Peter Kirsanow's comments that I want to make a comment about before I talk about where I see this administration going on race-conscious measures. First, I think that the administration is, in some ways, in a position that will require it to be a little bit more cautious than perhaps the Clinton administration was on issues of race. And here's what I mean by that. Here's President Obama, the first African-American president, and I know what that means for most Americans, but also what it means for people who have been concerned about the issues of diversity, and as many of the folks in this room like to focus on, you like to focus on the word preferences. And certainly the election of President Obama signals a profound change in this country, and one that I am willing to say I did not think I'd see in my lifetime. Many people are willing to say that, or some people say they thought that they would see it, but It's extraordinary when you think about the fact that we are only a mere, 40 or so years past the time when legalized discrimination was intact. Loving versus Virginia, 1967. The Fair Housing Act only passed in 68. I could go on. The Voting Rights Act in 65, the Civil Rights Act of 1964. It's not a long time, particularly when you think about the fact that of our 233 years as a nation, 178 years have been spent in either slavery or de jure discrimination, if you use Brown as a cutoff point, which is being too generous, because of course legalized discrimination continued beyond Brown. So something like close to 80% of the days of African Americans in this nation spent in either legalized discrimination, Jim Crow, or slavery. You go back to the arrival of African Americans at Jamestown, and we're talking about 390 years, 335 of those years, slavery or Jim Crow segregation. Often when I point to that, people's eyes roll up in their heads because they don't like to talk about what's unpleasant. But these are often the same people who are very willing to celebrate the 400th anniversary of Jamestown, or to talk about, as we should, the extraordinary things that the Founding Fathers did. But history is not, doesn't speak in half a voice. We can't be selective, but we shouldn't be selective. And so when we think about all of that, think about all the structural inequality of this country, which of course was the basis for taking measures, affirmative measures, that would undo those structural measures, or inequalities rather. Those efforts only began about 40 years ago. So it's extraordinary to have an African American president elected, and we could say a whole lot more about that. The point that I'm making, however, is that structural inequality that exists, the legacy of all that discrimination, which some folks, as I said, don't want to see or don't want to talk about, didn't go away on the morning that Barack Obama was sworn in as President of the United States, although certainly there's some excuses, you might say, that no longer obtain, that are no longer on the table. That is, it is possible for any individual to do something like become President of the United States, and that wasn't clear before. That has happened now. But the structural inequality hasn't gone away, it still exists. What do we do about that? I think what we do about that is continue the work of taking affirmative measures to undo it. When you talk about the Michigan case, in which I was deeply involved, don't have time to talk about all the details of how I was involved in that case, but I'd be happy to do it. I was deeply involved not only as counsel for Black and Latino students in the undergraduate case, but deeply involved as a faculty member at Michigan during the time I was away from the Legal Defense Fund in calling attention to some of the practices of the law school that required some change in order to bring the law school into compliance with BACI. And in initiating, in fact, the review of those programs and in serving on the committee that drafted the policies that were the subject of the litigation in the Grutter case. I wanted to underscore the fact that the Michigan case sat on top of a whole pyramid of inequalities. Elementary and secondary school education. I don't need to tell you all about this because you know about it. You know, for example, that the schools in Detroit don't give the same education to Black and brown students in many instances as schools in the suburbs. You may conclude that the Black and brown students are unqualified. We could talk about why that isn't the correct conclusion, at least not with respect to all of them, or the ones who are admitted under a properly structured affirmative action program to the University of Michigan. What you don't know, for example, or what you may not know, is that the University of Michigan undergraduate process gave credit to students from schools that were that had high SAT scores. Now think about this. This is not credit given to individual students for their accomplishments, but for the average SAT scores for that school. Those schools were ranked higher in the process. The consequence is that a student from that school, regardless of how poorly or how well he or she performed on the SAT, and regardless of GPA, would get the benefit of that ranking of that institution, which was factored into the admissions formula.